pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I wasn't here for the last meeting, but the rest of you were, and the minutes have been written. Does anybody have any corrections or additions? If not,
We accept the minutes.
all right. All those in favor?
Aye.
All right. Now, any opposed? If not, the minutes are approved as written. I have no announcements. Are there any from the code officers? Nothing to tell us? All right. Then I'm going to swear in everyone who is going to speak tonight. What's the matter? Administrative problems? Oh. Oh, no agenda. So everybody who's going to testify tonight, they need to stand and be sworn in. Yeah, well, I'm swearing. That's everybody. Yeah, please.
I, and say your name. Do solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matters set forth before this board.
I do as enough. Yeah.
Sorry, that's real. Thank
Okay,
you.
you've all been sworn in. Then we'll get to the first case, 173382. And who's going to, Anna, you're going to talk to us about
It's
it.
me again.
Okay,
Good evening, board members. Officer Anna Reichert for the record. I'm submitting this non-compliance hearing for the record. And this is regarding case number 17-0003382, property owner Linda G. Burns. The final order required compliance on or before August 9th of 2018. The property remained in non-compliance until August 15th. Fines accrued for 5 days, August the 10th through the 14th. So I'm requesting fines be assessed for that amount, the $250 per day for the 5 days.
5 days,
Yes, sir.
and
$1,250.
$12.50. And what was the violation?
Violation was, sorry.
Coastal Lake,
Yes, sir, it was the coastal lake clearing without a permit in the protected area.
She was clearing the property without a permit, and how did she
Correct.
come into compliance?
She came into compliance on August 15th. Is that what you asked me?
No, how did she do it?
How? By
Yeah.
submitting a restoration plan.
Okay. And she has some period of time in which to execute that plan?
Yes, sir. I believe, I haven't confirmed this, but I believe we'll probably close this case because she did comply,
Yeah.
and then reopen a case for her restoration so that she follows through with that plan.
Okay. Is she here? Is someone on the, no, she's not. Well, any questions?
Yes.
Victor?
She been very cooperative and in terms of what she is undertaking?
It's taken her over a year to come into compliance.
And did she have a good reason not to have come into compliance? in
If
that
she
year?
did, she didn't
She didn't communicate
express it
with
to me, no,
Yeah.
sir.
Okay. Any other questions?
And this was a coastal Boone Lake issue.
Okay.
I have a question.
Yeah.
Did you see this person?
Her, no, I've never met her, sir.
It came in the mail, the plan came in the mail?
Well, it goes to the planning department, and they're the ones that relay to me when she's complied as far as turning in all required documents, the restoration plan, those things.
Okay, so it's a written plan,
Yes.
okay.
So the total amount of money we're talking about?
I did.
$1,250.
Yes, sir.
All right. Anybody want to make a motion?
Or you want to close, oh, you don't, guess you don't have to. I'll make a motion to accept the fine.
Second somewhere?
I'll second the motion.
Okay, any discussion? If not, all those in favor? Aye. Any opposed? Then that carries unanimously. Okay, the second case, 182544. Ann, is that you again?
Yes, sir.
Wow, busy lady.
Busy girl.
I'm sorry. Reichert.
Okay, we're ready when you are.
Okay, I'm working on getting this iPad up and running. All right, this case is case 18-002544, the Eastern Lake Village Condominium Owners Association Incorporated. The violation concerns Ordinance 11.00.01, a development order required prior to undertaking any development activity. Sorry, this iPad for some reason doesn't go forward quickly. Eastern Lake Village condo, I sent the, on June 19th, 2018, a complaint was received regarding an illegal fence in a shared parking lot. I don't know why this is not going any further. That was on June the 19th, we received the complaint. June 20th, 2018, I conducted a site visit and observed a violation of section 11.00.01, development order required prior to undertaking any development activity, specifically installation of a fence within a shared parking lot without approval.
You said a shared parking lot?
Yes, sir. And as soon as this starts moving forward, we'll get to that. I've got a drawing from the site plan that will show that. Make it go forward. Oh, it finally did. Oh, my gosh. Okay. This is the property appraiser's website overview. Parcel number 19-3S-16550-AAA-AAAA. Property owners are shown as Eastern Lake Village Condominium Owners Association Incorporated. The address is 5231 County Highway 30A. Land use is village mixed use. June the 20th is my first inspection. I observed the fence there. If you can see that green thing there, I believe that's a green like landscaping cloth over a chain link fence. This is the view of the fence from County Road 30A. That's the driveway. There's a little wooden bridge right there.
Yeah, that's better.
And then in the background, to the left side, you'll see there's a dumpster that's overflowing. Okay, on that site visit, I spoke with a Mr. Brian Cooper, who's the manager of Buddy's Seafood, which is on the ground floor of this condominium. He admitted he and the other tenants had installed the fence. I advised him that the development order does not allow for the fence and it would need to be removed. I also advised him that a notice of violation would be sent to the property owner as listed under the property appraiser's website. On June 21st, the notice of violation was sent via certified mail to Eastern Lake Village Condominium Owners Association in care of Andy Phillips, registered agent, as listed under SunBiz. The corrective action was to cease all work and development activity until all permits have been obtained or remove the fence from the property. They received and signed for that notice of violation on June the 25th. My reinspection on July the 17th, you'll see the fence has changed from the first inspection, so they continued construction activity even after the notice of violation. And as you'll see, traffic flow from 30A there was blocked. And in the background on this reinspection, the dumpster is even more full and overflowing. The property owner adjacent to this stated the dumpster company could not get in here and would not come in here because of that fence to remove all that garbage in the dumpster. July 5th of 2018 was the deadline to correct the violation or to contact our office for plans to correct the violation. No contact was made by the property owner or the agent. This slide, upon my reinspection, shows there's wood that's taking up more of the parking spaces. The fence itself is also taking up parking space. So their required parking spaces have been reduced by, from my best count, at least 4. July 23rd, a notice of hearing was mailed, scheduling them for this code enforcement hearing August 16th of 2018. The notice was sent certified mail to the property owner listed on the property appraiser's office website as Eastern Lake Village Condominium Owners Association in care of Mr. Andy Phillips. July 27th, the notice of hearing signature card was signed and returned back to us. On August the 13th, 2018, Sammy Sanchez of the South Walton Fire District notified our office that the fence is a hazard and is preventing emergency vehicles any access to that area. Inspection today, August 16th, it revealed the fence remains in place in violation of section 11.00.01, the development order required prior to undertaking any development activities. The lumber remains in the parking spot there, blocking any further parking there. And it continues to block traffic coming off of 30A. And it's still blocking that parking space there. This slide is a copy of the site plan in the final order. The pink outline shows the areas that share parking and stormwater. The yellow shows the parcel that is in violation. The fence is installed along the yellow line that's vertical on the left side, the furthest left yellow line that's running vertically up and down. That's where the fence is installed.
Is it on the west side?
Is that the west side? Yes, sir. Yes, sir. And again, it goes from end to end, from the north side down to the south side of the property. The development order requires shared parking and shared stormwater for both parcels. The erection of the fence has separated the parcels and changed both parking and stormwater plans, which requires a revision of the development order. My findings. This is a lawfully constituted code enforcement proceeding convened pursuant to Chapter 162, Part 1, Florida statutes, and Chapter 12 of the Walton County Land Development Code. The Code Board has jurisdiction over the subject matter and the respondent. Notice of this proceeding has been duly provided to the respondent as required by county code. The respondent, Eastern Lake Village Condominium Owners Association, by reason of the foregoing facts, is in violation of Section 11.00.01 of the county code. The respondent is subject to the enforcement jurisdiction of the Code Board. It is my recommendation that the Code Board determine that 1, the address of 5231 County Highway 38 East is located within the unincorporated area of Walton County and is subject to Chapter 12 of the Walton County Land Development Code, that proper hearing was given to the respondent, that a violation of the Walton County Land Development Code Section 11.00.01 does exist on the property, that the respondent is to correct the violation within 3 days, with reinspection of the subject property scheduled for August the 20th, 2018, to verify compliance with this order. Corrective action being the fence be completely removed and all trash accumulated be removed and the dumpster emptied, and the parking lot put back into the previous condition to allow free flow of traffic, free parking, and fire and emergency access. That if the respondent fails to comply with the above action or fails to bring the property into compliance with the applicable codes, ordinance, and regulations according to this order, that the board assess a fine of $250 a day until the property is brought into compliance.
Commissioners, real quickly, we would like to introduce into the record a copy of Anna's presentation. I believe Mr. And then also, so I guess if we could have that as staff's Exhibit 1. And then we have a composite Exhibit 2, which includes information from the property appraiser's website, a copy of the 2004 development plan, an excerpt from the Chapter 11 of the Land Development Code, the SunBiz information for the property owner, a copy of the notice of violation, and the notice of the Code Board hearing. And I believe Mr. Pleat's seen all those.
And you have no objection to this being introduced, then we'll accept them as Exhibits 1 and 2.
And, Mr. Pleat, do you have any questions for Anna?
No.
Okay. And just real briefly, before we close our case, we were going to call Mr. Carpenter up.
You have been sworn? And Renee, would you?
I, Matt Carpenter, do solemnly swear to tell the truth, the whole truth, and nothing but the truth.
And I realized for the court reporter, I did not state who I was. I'm sorry. So I am Sydney Noyes. I'm the county attorney, and I'm representing the Code Board staff. Thank you. So, Mr. Carpenter, I'm going to show you a document. This is a development order and a copy of a site plan from 2004, if you would take a look at it. Does this look familiar to you?
Yes, it does.
Okay. Can you tell me what this development order and plan is for?
This is the original development order.
Mac, would you step to the
Oh,
microphone?
sorry.
Yeah.
This is the original development order approved for this entire site.
And whenever you say entire site, that is the parcel that has been cited for the violation and the neighboring parcel to the west, is that right?
That is correct.
Mr. Carpenter, on this plan, is there any indication that a fence would be allowed under these plans?
There is no indication of a fence proposed.
Is the fence depicted any place on the plans?
There is not one depicted.
Okay, specifically, is there a fence depicted along the parking between those two
There is no fence depicted where the subject fence of this proceeding has been installed.
I would like to introduce this as Staff's Exhibit 3.
Yes. Do you object to the introduction of that?
Is that the development order?
Yes.
No objection.
Mac, I'm sorry, Mr. Carpenter, I'm also going to show you a document. This is a development order and a plan from a development order from 2016. If you would just take a look at it and see if that looks familiar to you.
Yes, this is familiar.
Okay. Can you tell me on these plans, is there any indication that a fence would be allowed where it is currently constructed?
Point of order, could you just, is this the amended development order?
Yeah.
Okay, thank you.
There is no fence shown in the middle of the drive aisle where one has been constructed.
And I guess just real briefly, if you would, Mr. Carpenter, would you explain to the board the significance of this fence being placed, blocking the shared parking access for the development?
The fence that has been placed there blocks the main entrance coming off of County Road 30A and prevents the access of the 10 parking spaces to the left on the Cotamola site, and at least 5 spaces to the right in front of Buddy's Seafood. It also prohibits Waste Management from accessing the dumpster in the northwest corner of the parking lot adjacent to the Cotamola site.
I would like to introduce this as Staff's Exhibit 4, which is a copy of the development order from 2016.
No objection.
Okay, we accept that as number 4 then.
Mr. Fleet, do you have any questions?
I do, yes.
Before you do it, could we ask some questions?
Sure.
Is there another access to the parking lot
Yes.
from the west?
Yes, there's an access to the east.
But how do you get to the parcel to the west if the fence separates?
There is no other access to the parcel to the west.
And what is in that parcel?
There's a 1,600-foot retail building with one apartment above that.
And they have no access?
Their access is blocked by this fence. They have a temporary construction access because they were completing the construction of this site, but there is no other business access to this site that we would approve.
Is there a property line anywhere near this fence?
Yes, there's a property line that runs right through the middle of the drive aisle.
Right through the middle of the driveway, is that what you said?
Right through the middle of the driveway. It's a shared driveway. Part of it's on one parcel, part of it's on the other parcel. And before the condominium was actually recorded, this was one unified parcel.
Okay.
Now, can I ask a question?
Yeah, go ahead.
I'm looking at a picture here. Are we looking at an unnamed driveway just to the west of the condominium that goes into that parking lot?
The dirt driveway west of the improved driveway.
Oh, maybe you want to look at that. Here's the building. There's a driveway here. There's a boardwalk running along the back of that driveway. Is that the area?
Right, that is the area, and right underneath where those trees obscure the parking lot
Yeah, we can't do
is
this.
where the fence is.
You can't use items that are not within, that's not been presented by.
Oh, I'm sorry. I won't do that anymore.
Okay. Do you have more questions for the county before we turn it over to their attorney?
Do you have any idea what the purpose of this fence was?
I don't know what's in the minds of those that installed that fence, but in my personal opinion, it looks like it's been installed out of spite due to some
Objection.
disagreement.
Yeah, well, I'll accept the
Personal
objection.
opinion. It's a
Yeah, we
personal
don't need to-
opinion.
Right.
Do we know do we know who built the fence?
It was built by Buddy's Seafood.
Buddy's Seafood, okay. And is he an owner in this condominium?
Yes, sir, he is.
Yeah, question.
Yeah.
It was mentioned that the fire department made an opinion or gave an opinion on this fence as obstructing the ability for them to get in.
Objection, that's not part of the record. but I'm glad to address it if it is going to be
I thought
considered.
that Anna introduced that before.
She did introduce it.
So
Yeah, it's in
what's
the-
your
It's in
objection?
the order. It's in her recommended
And it
order.
would be in exhibit number 1.
It's the testimony of Ms. Reichert, but Mr. Sanchez is not here. Yeah.
But
But I'll address it in my.
Mr. Sanchez spoke to me directly on the phone, and he said it's definitely,
Do you want to object to that because it's hearsay?
Of course, but I will also be providing information about conversations with Mr. Sanchez through my client. So to the extent it's already been referenced in the presentation by the county, I think that speaks for itself, the representation of the county. I think as to any further conversations she may have had, it wouldn't be appropriate at this point. But I'm going to ask my client to talk about his conversation with Mr. Sanchez to that degree. I suppose it's fair.
Okay. Any other questions then for the county among the board members? If not,
I don't think Anna was allowed to answer the question about what Mr. Sanchez, there was a question about.
oh yeah, you objected and you never got to say.
my only comment was that Sammy Sanchez spoke to me personally,
And said,
that it was definitely a hindrance for the emergency vehicles to go in there.
okay.
And he's with
He's the-
Walton,
he's the
Southern
County Fire
Walton.
Department.
South Walton.
He's the fire marshal for South Walton.
Okay.
May
Sir,
I
would-
ask a question on
Yeah,
that issue?
would you introduce yourself to us?
I
and
sure
then-
will.
Yeah.
My name is David Pleat from the law firm of Pleat and Perry. I
Okay.
represent the Eastern Lake Village Condominium Owners Association, Inc.
Okay.
And that's, you're not associated with Buddy's Seafood?
Yeah,
I represent the members of that association, and Mr. Buddy's Seafood is one of the members, one of the commercial owners.
So this is a commercial condominium and a residential condominium
It's a mixed use,
combination?
correct.
There's residences on both sides of this fence?
I'm unaware of what's going on in the building on the western side of this parcel.
There are residences on both parcels. One on the Cotamolo parcel and I believe 6 on the upper floors of the condominium building.
Okay, if we have no further questions, sir.
I just have one question for Ms. Reichert, who's been very pleasant and professional in my dealings with her. I want to make that clear. Ms. Reichert, are you aware that Fire Marshal Sanchez has also met with members of my client, and they have agreed upon a solution for the turnaround of emergency vehicles?
No, I spoke with Sammy Sanchez on Monday, this past Monday, which is the 13th, I believe
I
it was
don't
the 13th. And I requested that he send me something in an email, and I didn't receive anything. So, no, what has happened since then, I'm not aware of.
Understand.
Okay, would you like to tell us your side of this? Would you mind coming up?
I'd like to question Mr. Carpenter if I could.
Okay.
Good afternoon, Mr. Carpenter. Good to see you again. This is a little awkward since I'm to your angle here. I know you're very familiar with the history of this project. You will agree with me, would you not, that back in 2004, when the original development order was issued, there was a single owner of what now are the Cotamolo and the condominium parcel, correct?
I believe we had one owner for the approximately 1.46 acre parcel.
And that was Eastern Lake Village LTD, the developer, correct?
I don't recall the specific name, but it's on the development order.
And that development proceeded to construction within the first year after the issuance of the development order in 2004 in the completion of what is now known as the condominium structure, correct?
I believe that's correct.
The building, which is we're calling the Cotamolo building on the western half of this parcel now, that wasn't constructed in the original construction by Emerald Coast Village LTD, correct?
That is correct. It was approved to be constructed, and the infrastructure was approved to support that building also.
But it was not built. My question was it built at the same time of the condominium structure?
No, sir. It was just recently built.
And in fact, in February of 2013, there was a lot split whereby what was once a single parcel developed by Emerald Coast Village LTD was split in two separate fee-simple parcels, the condominium parcel and what is now known as the Dakota Molo parcel, correct?
I'm not completely familiar with that particular transaction. I know the condominium was recorded in 2006.
Is it your testimony that the county is unfamiliar with a lot split that was approved by the county for the split of these two parcels?
I'm personally not familiar with that.
And all your dealings on this case, you're not familiar with the fact that in 2013, there was a division of this parcel whereby separate deeds were issued for the two parcels?
This parcel went through foreclosure, so I'm sure that at some point it was separated from the condominium.
And as we sit here today, there are two separate deeded parcels, the Cotamolo parcel and the association parcel, correct?
The association parcel and the individual condominium units within that.
The complaining party in this case was the Cotamolo representatives, correct?
I'm sorry?
The complaining party in this case was the Cotamolo parcel owners, correct?
I believe that's correct.
And there's been reference in Ms. Reichert's testimony to shared parking lot. I think you might have made one reference to the shared parking lot. Will you tell me what is the basis? Is there an easement? Is there some type of license? Is there something in the plat which indicates that these two separate parcels that are owned separate fee simple have some kind of legal shared parking arrangement?
Yes, it's the 2004 development order.
I understand the original development order called for more parking. My question for you is, since the lot split, what is the basis, what creates a real property right in the association parcel that would allow the Cotamolo folks to have legal access to their parking lot?
The 2004 development order.
What in that order, it's in the record, why don't you point to me, what in the development order says that if this is eventually split into two parcels, that one of the parcels will have a favored use of the other parcel through an easement or some other mechanism?
The development order did not contemplate the parking lot being split as it has been split.
Exactly. So when the original development order was issued and approved parking, it was expected to be one development, correct?
It was originally approved to be one development, but it's quite common for development parcels to be sold after the original development order has been approved and the buildings have been constructed. Certainly the condominiums have been sold to others. They were all owned by the original developer at one time.
Those units were sold well before the lot split, correct? Those units in the association were sold well before the lot split in 2013.
They were sold in sometime after 2006 when the condominium was filed.
And prior to the lot split, correct?
I would imagine. I haven't done that research.
And in fact, as part and parcel of the development plan presented by the developer in 2004, there was recorded in 2002 by the developer a mutual access easement that covered the entire parcel as well as the parcel to the north, correct?
I don't know.
And
not aware of that.
Are you unaware of the fact that Cotamolo, the complaining party in this case, sued to void the very easement that gave it access to the parking lot of my client?
We were not parties to that litigation, and I've only recently found out about it.
All right, so the county, through you are aware of that, correct?
After the fact, but
And
not in detail.
And you're aware at the urging of Cotamolo to void this easement that gave it access to my client's parking, Judge Green, in considering the law of merger, voided the very easement that created a legal right of access to this parking lot of my client's, correct?
I'd have no knowledge of that information.
No further questions.
Just real briefly, Mr. Chairman, we would like to reserve some time for rebuttal after Mr. Pleat presents his case.
Okay. Mr. Pleat, would you step to the podium, please?
I can't hear him.
Yeah.
She said they want rebuttal after he gets done with his presentation. We'll allow that, but first we'll hear his presentation.
Would you spell your last name, please?
Pleat,
Sure will.
P-L-E-A-T.
Give me just a moment here to make sure I got this working correctly.
And Mr. Pleat, was your client present when we swore in the witnesses?
I don't think, he may have come in just after. That's Mr. Jason Oakes. He's the president of the association. If I call him, I will ask him to be sworn first. Thank you for that reminder. Good evening, members of the Code Enforcement Board. Again, my name is David Pleat. I'm an attorney and I represent the Eastern Lake Village Condominium Association. My last name is spelled P-L-E-A-T. I think someone just asked that question. I've practiced here for 24 years, total of 33 years of practice of law. I have a presentation. I'm not sure how to get it up.
It timed out, I
Thank
believe.
you.
That didn't help a bit.
I'm trying to get it up
It
here.
can get better.
It'll get better.
Okay. Thank
There
you.
we go. Westinghouse.
I have hard copies just in case, if for some reason it does not work.
Looks
Very
like it
good.
worked.
Thank you.
Plug and play.
All right. The notice of code enforcement board hearing and as well as the violation letter that went out, that's part of this record. It's important to note that it's a parcel number referenced, which is a unique fee simple parcel number just for the association, not for the whole parcel that was approved for development order in 2004, not for Cotomolo. This is a separately deeded property of my client that they own, fee simple, and that is the actual parcel number referenced as being the party that this is the subject, the proceedings the subject of.
What's the date on that piece of paper?
That is July 23rd, 18. That's the notice of code enforcement board hearing, which was presented through Ms. Reichert as well in her testimony. I wanted to give you some perspective of what we're talking about here, since it may be confusing at times just hearing the description. As you can see, we're looking at Eastern Lake. The parcel to the lower left, the building, it's a several-story building. That is the Eastern Lake Village building, which is a mixed-use building. We have commercial tenants on the, commercial owners on the bottom floor as well as residential on top. This is a bit dated of a picture. It does not reflect on the western parcel, which is the Cotomolo parcel, the complainant's parcel, a building which has been constructed that is apparent in some of the pictures that Ms. Reichert had presented. That's another angle, another view. If you look at the right upper portion, again, you can see the condominium. You can also see the entrance road where the fence splits on the property line. That road, there was a question about that, and you can see it in that picture. The next item is an application for a lot split going back to the original parcel in the historical record of this case, which included Old Florida Fish House, the Cotomolo parcel, and the Eastern Lake Village condominium. It used to be one owner, Three Amigos, Inc., and that was split into two, a north and south section. The south section making up the parcel that eventually Eastern Lake Village LTD, no relation to the association, developed in 2006.
Did that application apply to both sides of this piece of land?
It did, and we're going to see a picture of that in a moment. The development order was introduced by the county in its case. The development order goes back to December of '04. This was the original development order for the entire parcel, which makes up now two parcels. It was a development order that allowed for the development to start within a year. Development did start within that year. And these are some records that I've pulled from the original development order that are germane to this whole issue. If you will notice in this item, this slide that's up right now, this is back in '06 when the development order was being considered. And this is a letter to Mr. Harmon from the engineer at Emerald Coast Associates, acknowledging that the western building, which is now the Cotomolo building, when the lot split, the Cotomolo building, was not constructed. The building was planned to include 2,000 square feet of retail and 2 residential units. Not constructing this building, the Cotomolo building, allows a reduction in parking of 10 spaces after 20% reduction is taken for retail. So there's a consideration when they approved that original development order in '04 that they were reducing the number of spaces because the developer said, I'm not building this other building, which now is the Cotomolo building. An entrance had been added to the restaurant parking lot, reducing the parking spaces by 3 spaces. The parking loss is offset, however, because the building was not constructed, meaning the Cotomolo building. So clearly, the contemplation at the time was, as we establish parking, we're taking into consideration they're not going to build this second building, and therefore there was a reduction in the parking. again, there's a letter here from Jim Harmon to the file, noting, this is back in 2006, when this development began, the western building indicated on the approved plans was not built. If and when this building is constructed, a separate inspection would be necessary to verify compliance with the plans. There's an important timeline here, and I'll try to move through this quickly. I told you about Three Amigos being a single owner of all those parcels. Then there was a split of those parcels and a development order granted for the Emerald Coast, the Eastern Lake Village development order in 2004. And they completed that building, which is the association building, in '06. Then there was a period of 7 years before there was a lot split. Don't know why it happened, don't know the motivation of the developer, but there was a lot split in 2013, which created what was then a vacant lot to the west. And the property line where the fence is the property line which was approved originally for that portion of the development order. And there's two separate deeds. If you look in land records, I will proffer to you, there are two separate deeds for those two parcels in 2013. After the lot split is when the Cotomolo folks sought and obtained development rights and building permit for their building on the western parcel, a separate fee-owned parcel.
I'm sorry, Mr. Chairman, just real quick, I would like to clarify one point. This lot split from 2013, that's not a county-approved lot split.
You have rebuttal. It's clearly
Okay.
a lot split. There's two separate deeds.
Okay.
And I don't think the county's going to dispute the fact that there are two separate fee simple parcels here. And like I said, the developer decided to do that, obviously to sell the separate for whatever he could get for it at the time.
And that was done in 2006?
That was 2013. In 2006, the development was completed, the condominium building. And in 2013, there was this lot split whereby the owner of the parcel split into two halves. Separate deed for what was then an open lot, and then the association owns their parcel that they sit on right now. The original developer, Eastern Lake Village, sold to Cotomolo in 2014 what was an undeveloped parcel at that time. I have a copy of the declaration of the association simply to show that the association did in fact get formed back in '06, and each of the owners owns a derivative pro rata interest in the common elements, which includes the parking lot in question.
Any other items in that list of common elements?
There's the parking lot, the sidewalks, elevator, the hallways.
Pool?
There's no pool. Yeah, there was a pool on the western parcel. I don't know if it still exists. I think it does, not used. But there's no pool access for my clients on a parcel they don't own.
Just the elevator?
And elevator, hallways, sidewalks, parking lot.
And who maintains the elevator?
The association.
Your client?
Yes, correct.
And others on the other side of this fence use that elevator?
Oh, no. I mean, unless they're a patron coming to one of the stores or going to visit somebody in the condominium, they don't have they're not a member of the association. They have no association member rights.
Okay, so the condominium is on one side of this fence?
That is correct. Yes, on the eastern side.
Are there any structures on the other side of this fence in that lot?
In the association lot or the?
No, in the
yes, there
lot
is.
on the other side of the fence
Yes,
from your
in
client?
2014, Cotomolo bought that parcel, the western parcel, and has since developed a two-story, I think, a building, which is either near or at completion at this time.
Not attached in any way to this fence
No.
or your property?
Totally, completely on its own, separate meets and bounds, fee simple, deeded property.
And do you know if they have any development orders pending or working or anything like that?
Well, they sought an amendment to the original development order when they built their building, and apparently the county approved that and allowed them to build their building through an amended development order back in 15 or 16, I think it was. I included this just to show, you can see the actual legal boundary lines of the association that they were deeded by the developer. You see a flagpole on top, that's part of the Cotomolo parcel. Cotomolo has what would be a square parcel, with the exception they have a strip of land that runs to Heron Watch Way along the top of this site plan. You can see it. But the clearly demarked square, and you can see where the property line of Eastern Lake Village Association goes right down the middle of that drive and through the parking lot itself. This is another depiction boundary survey associated with the construction of the condominium association. Here's a survey that shows the separation of the parcels into two separate legal descriptions, two separate fee simple parcels. Again, you can see where that line of my client goes right north to south from the drive to the corner, the north corner of their lot. This issue was obviously an issue back in February of 2015 when there was some question about the Cotomolo's intent to develop on this parcel. This is a letter to Vivian Schammel from Mr. Carpenter asking her to research the condo docs to see for any easements, agreements for the built condo for a variety of things, and shared parking agreement, and that's important, I'm going to come to that in a minute, asking about any shared parking agreement that can be reasserted across the remaining development parcel presently applying for building permit. In the second paragraph, we are considering a new procedure for reviving, managing these old unbuilt phases of legacy DOs. So this was a work in progress, trying to figure out how to allow building on that new separate parcel. This was the minor modification in April 2016. This is when Cotomolo went to the county and asked the county to permit it to build a structure on the western parcel. And you can see from the site and geometry plan, clearly two separate parcels, the Cotomolo parcel to the west and the existing condominium parcel to the east.
Mr. Pleat, do you have hard copies of this that we can?
I do. I have 10 extra copies.
Huh?
I have extra copies.
We'd sure like to see them, because it's difficult to see
Okay.
that.
Very good. Excuse me.
What's that? Oh, even that.
I have 7 total actually here. One I'd like to make part of the record, if I could.
The
And then
county doesn't object to the introduction of that, do they?
No. And here's 6 more copies. I'll hand to the clerk. And I'm currently on page 47. I'll wait for you all to get your hard copies.
Holy shit.
You're on page what, I'm sorry?
Page 47.
Everybody got one?
Dave, could you please back up about 3 to show the overall?
Sure, yeah, I can go back to page 41. That's a pretty clear picture, I believe. I'm on page 41, members of the board.
Yeah, there's and some of them have numbers.
If you look at the lower right, there should be ELV number, that's the page number, 41.
ELV, elevation?
No, that's Eastern Lake Village.
That's his.
Holy moly.
And this parcel A, that's the entire parcel, or that's the eastern part of it?
The parcel A is the actual structure of the condominium.
Yeah.
You can see a square boundary mark for the actual property owned by the association. It dissects the parking on the west and the drive to 30A. And then to the west of that marked line is the Cotomolo parcel beginning, as well as this flagpole on top, which is also Cotomolo.
Is that on, are you looking at 41?
Yes, I am. Yeah.
Well, where's the flagpole? I'm not sure.
If you look at the gray parking area, north of the parcel A structure, there's a piece there that runs the left to right on your page. That is the flagpole parcel, portion of the parcel that Cotamolo owns.
Is that page 41 on the screen?
Yes, that is actually 42 on the screen. No, I take that back. It's 47. I backtracked. Mr. Bowen asked me to go back, so I'm not quite there yet.
So what do you want us to look at, 47?
.43's a pretty easy one to see.
43 is a fairly clean depiction of the separation of the lots that occurred in 2013. And that's my page number 43. It's the ATLA ASCM Land Title Survey. It shows you the two parcels, the dividing line down the drive and parking area, as well as that flagpole piece of Cotamolo that I referenced to the north of my client's property.
Is this fence within the coastal dune lake protection zone?
No, sir. I would submit the construction of the Cotamolo building is.
Let me understand, on this parcel 1, is that swimming pool in parcel 1 and that walkway in there too?
Yes, I understand they're still there, but my client doesn't own that land. My client has no access to that, to the walkway, to the dock, to the pool.
He doesn't own that?
No. My association client owns the eastern parcel. The complaining party, Cotamolo, owns the parcel where the pool is depicted and where that walkway is.
Okay.
If you forward to page 52, this is part of the submission from Mr. Ed Stanford, who's someone I've known for many years, a very capable civil engineer who was presenting plans to the county for Cotamolo for the construction of the parcel, the Cotamolo parcel. On page 52, you'll see where there's the proposed building marked by Mr. Stanford on this landscaping plan. And interestingly, the proposed parking for the project, you will see that that proposed parking is entirely on the Cotamolo parcel. It does not rely or reach into my client's fee simple property. And if you go to the next page.
Wait, let's stay on 52 right
Okay.
now. That brown, is this brown line coming down the middle of that page?
Yes.
Is that essentially where the fence is now?
No, sir. That's actually running east to west. I believe that's the walkway to the dune lake. The fence is on the property line, which you see, which would be that line on the far, what would be to the east, right along this proposed parking in this landscape plan.
So the building that was built conforms to where this is? Or is the building that was built not where it says it's going to be built?
It's my understanding that the building is built approximately where you see it says proposed building on this particular page. It abuts 30A, the structure itself. And on the next page is where you see another submission from Corps Engineering. And again, you'll see a contemplation of parking entirely on the Cotamolo parcel, honoring and respecting the property line between the Cotamolo parcel and the coastal dune lake. Eventually,
Was this ever submitted as a prospective order, or?
it was part of one of the original submissions by Mr. Stanford. Eventually, the county approved it without the need for additional parking spots to be placed on the Cotamolo parcel. On page 67 is where we see the actual development order for Cotamolo. Different parcels. Page 67, yes. And that's where they sought and obtained a development order amending the 2004 development order, allowing for the construction of this building on the Codemolo parcel. And in the interest of time, I'm going to go to what I think is probably the most important document in here on page 86.
86?
86, yes, sir. As I mentioned in my cross-examination of Mr. Carpenter, reference has been made to shared parking lot. What the county is asking this board to do is to use its board authority to impose land use rights on my client's parcel for the Codemolo owner. In other words, asking you to determine that there is some legal interest that they have, that Codemolo has, to use my client's parcel. Interestingly, the developer must have anticipated this may have happened someday in the future, that he decides to separate parcels and sell them separately. So back in September of 2002, before the original development order is issued, the same developer, Eastern Lake Village LTD, files and records a mutual access easement agreement covering the entire parcel, which was then one parcel, the Codemolo half and the Eastern Lake condominium half. It also benefited the parcel to the north, which is which is Old Florida Fish House. So this was intended at the time to provide what I just mentioned, a legally supportable access to the parking throughout the parcel. This was a broad mutual access easement. It meant you could cross any part of the overall parcel, use it as you wish, but it provided legal rights to what is now Codemolo, my client, the association, and Old Florida Fish House. They all enjoy the benefit of mutual access. That's why those of you familiar with Old Florida Fish House, for example, people would come off of 30A and sometimes they'd park in my client's lot, park in the Old Florida lot, or cut through entirely over to Heron Watts Way. All three owners benefited from that. So what happens? The complaining party in this case, Codemolo, sues to void the very easement that would give them a legal right to be on my client's property, based upon what is the doctrine of merger, because at one point in foreclosure there was one owner of all of these parcels, and therefore it extinguished their argument was, which was agreed upon by Judge Green, who's a fabulous judge, found that this easement was no longer legally enforceable. So the party complaining that they can't get to parking on land they don't own had a legal easement, but they sued to void the very easement that gave them that access. Instead now, they're asking you to impose upon my client basically an easement or some kind of license or some deeded interest in their parking that Codemolo doesn't own. So
let me just interrupt you right there. I don't think the county said anything like that to us.
Well, I'm suggesting the implication is, in order to find that there's
let me ask you a couple of questions.
Please do.
Do you plan on providing fire and paramedic services to 24 hours a day? Because our services that we're providing as part of this county can't get in there right now.
Well, I will tell you, because I was at the meeting, and I'll be glad to put my client on, who was also at the meeting with Fire Marshal Sanchez. There was agreement reached, and he was completely satisfied that my client was going to demarc two of their parking spots to be turnaround for any emergency equipment and remove an area of sidewalk that would also allow that. He was 100%, he said, that will solve the problem. I'm glad we had this meeting. I'm good.
All right. Number two, does your client plan on doing anything about the garbage he's letting pile up in his dumpster?
Well, that's an interesting question, because the suggestion is that they can't get in there somehow and get the garbage out. They chose to put that dumpster where it is. They could move it forward towards 30A if they wanted to. It is not my client's responsibility to determine where they put their dumpster.
Wait. It's the association's dumpster, right?
No, it's not. It's Codemolo's dumpster. It's the neighboring property's dumpster on the other side of the fence, which is now a complete fire hazard, according to Mr. Sanchez, and an eyesore and a nuisance because it continues to pile up, deliberately
And
so.
The reason it's piled up is because of this fence, which work was begun without a development order or any kind of other permission from the county to do so.
Well, it suggests that one needs a permit to build a fence on their lawful property line, and I will submit, Cotamolo has fences on its parcel that have not been part of any amended development
How
order.
high is it fenced?
6 feet, I believe.
You don't know?
I can check with my client, but. 8 foot. 8 foot.
So you don't have any plans to provide garbage service to your next door neighbor?
Nor is there any legal obligation to do so. They chose this parcel, they bought this parcel, they have their own reason to do diligence on whatever level they want. They got a development order, they had access to my client's parking lot. They chose to legally seek the voiding of it and succeeded. So to suggest that my client now has to provide services to a neighboring property owner who voided the very easement they all benefited from is asking something that's not required, number one, nor would it be fair, in my opinion.
Well, wasn't it customary for your client to let, at certain periods of time of the day, for people to pass through part of the parking lot that was jointly used in periods before?
For years.
Wasn't that customary use of this?
It was from 2002 until Judge Green's order. Everybody did that because they knew the easement provided those
And
rights.
that provided no benefit for your client or?
It
or
did.
the
My
Buddy Seafood?
client, as well as Old Florida Fish House, fought it. They said, "Why are we doing this? This benefits us all. Why do you want to avoid the very easement we all benefit from?" And we're unsuccessful because of this doctrine of merger. And Judge Green found, as a matter of law, that he had to void the easement.
Do you have any idea what their motivation was for suing?
I think it would be improper for me to impose, my understanding of what might be going through someone's mind. I will say that the public record will reveal that there's been a great deal of animus amongst owners here, and so I don't know. Is the question about, I'm sorry, the fence or the?
No, look,
What's the motivation for the
Cotamolo sued to remove the easement, right? And
Yes.
they were successful in
They
doing
were
that.
successful.
And I'm asking you why they did that.
I don't know. It's counterintuitive to me. I don't understand it, but they chose to do it and were successful.
He hasn't been sworn in.
Do you know the answer? to
He
the
has
question?
not been sworn in.
You can certainly
Let's
swear him
swear
in
him
if you
in.
wish to proceed.
Would you please step to the front, introduce yourself, and be sworn in?
Is he being called by the county? I'm not sure.
Time out. We've got a
Wait,
sidebar.
wait, say-
You're not finished, are you?
I'm almost done.
Sydney, what's my problem?
I'm sorry, Mr.
What is my problem? Why can't I swear?
I think it might be better to wait till Mr. Fleet finishes his
Finish.
presentation.
Probably
I'm
so.
almost done.
Probably so.
And the question was, the motivation,
He doesn't know.
your question,
He doesn't know.
right. and the
Mr.
question-
Pleat does not know the answer to my question.
The motivation for the voiding of the easement. That's up to the plaintiff to speak to. The last item is simply the order from Judge Green, the final judgment which voided the easement. So, I understand there's a lot of information that's coming out through all this, but clearly, because of the separation of the lots, because the original developer contemplated use rights for the parcels down the road, because it no longer exists, the only way you can find that there's a shared parking requirement, legal requirement on my client, is to point to something, a license, an easement, an implied easement, a deed of some sort. None exists. The only easement that did exist is no longer legally there. So because of that, I'd ask that you not find my clients in violation. They have a right to put a fence up on their property. There is no, and the basis for the county's complaint here is that there was a shared, they're not allowing shared parking. To violate my client means you must find, according to the county, they have an obligation to share their parking lot with someone who doesn't own or have a legal interest in their parking lot. And I think that's beyond the scope and not fair to ask the board to come up with that conclusion that they have a legal right to somebody else's property. Thank you.
Okay, Renee,
Yes,
if the county wants to rebuttal, would this be the appropriate time?
I believe so. They,
So, we have no rebuttal, Mr.
This is you're the owner, right?
The president of the,
Okay, of the association, the condominium association.
and he's not been sworn in. Please state your name.
Keith O'Leary.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
And your position, sir?
I'm the owner of the parcel that Mr. Plea's been talking about.
Can you spell, say your name into the microphone?
Yeah, Keith O'Leary, O-L-E-A-R-Y.
And you say owner of the parcel, that is the condominium parcel,
No, I think there's been some confusion. I'd like to maybe,
you try to
provide some-
straighten this out,
yeah.
because I'm totally confused.
so Eastern Lake Village was,
I can't hear you.
so what, Eastern Lake Village was one parcel developed by a developer.
I'm sorry, Mr. Stein, I'm sorry to interrupt. I would like to have arguments, I guess, once we're close with the evidence. That's all right.
Okay, we'll give you a chance, yeah.
So it was one development, Eastern Lake Village. And so we, it's kind of like any development where it's got different parcels inside of it. Seaside.
Speak right in that microphone.
Seaside, Rosemary Beach, you have people that own individual parcels within one development.
Right.
The county approves the development. The county does not approve individual parcel ownerships.
Right.
And so Eastern Lake Village was a creature of the county, not a creature of the condos. Didn't come from me. Eastern Lake Village came from the approval process that was done by the development order. The development order approved certain infrastructure of which both parties benefit. The driveway, the parking lot, the drainage, the turnarounds, the through traffic. The county carefully looks at all aspects of the development to decide, is this meeting our standards? So the fact that I bought a parcel within the development does not allow another party to unilaterally change the infrastructure within that development. And that's the crux of this. Does the condo association have the right to block the middle of a county-approved parking lot that the fire department uses to get through, that is used for drainage from the condos into my property? So they put a fence up without notice. That's why my dumpster's trapped there. The reason that I filed a lawsuit against the Fish House is because they're not part of Eastern Lake Village, but their customers were using the driveway and parking in my parking spaces and in the condo parking spaces and jamming everything up, and that they wouldn't let me park my customers in their parking lot when I opened up. They told me that, as did the condo owners. They had a deal with the Fish House. I did not. So I had the burden of having all the traffic and all the parking on my parking spaces while nobody was willing to reciprocate. So in order to protect Eastern Lake Village, I went through the proper procedure, which was first to try to work something out with my neighbors. They were unwilling. So to protect the parking lot of Eastern Lake Village, I filed the lawsuit to close off the easement. Mr. Pleat is incorrect. The easement was not a blanket easement to do whatever you want, wherever you want. The condos made it very clear to me, they're not going to let my customers park in their spots, which is fine. I wasn't asking for that. But there is a driveway that is shared. Their customers, even to this day, still park in my driveway and walk over to Buddy's Seafood. So there's still this expectation of the community. This is one development, and it's impossible to have this fence there without causing problems with the fire department, with my dumpster, with the traffic flow, with the drainage that is going into my property. They put a fence up, but they're still using my drain basin. Okay, so that's why the county has a process of, if you want to split up this development, you need to go through a development order process. And then we can make sure the fire department's happy and the traffic works and the parking is adequate. I don't know if Mr. Pleat told you, but they lost about 7 parking spaces because of their fence. Not me. I lost a bunch of parking spaces too, but they did. But they still have an ongoing business there. I can't open my business because they blocked me before I could open. But they're continuing to operate their business in violation of the ADA, in violation of the fire department codes, in violation of the county regulations for parking. So I don't think you have the full story about what this fence means. If they want a fence there, that's fine. Let's go through a process. Just like when I tried to build my building, they fought me, didn't want me to build my building. I went through the process for 2.5 years and got approval. I didn't just build a building because I wanted to. I went through the process. I respected the process. And I'm asking you to make them respect the process too. If they want to split it up, great. It's not a lot split. There's 2 interests within this community, but it's one development.
What's the nature of your business?
We're going to be a retail store. But we can't open because they blocked us. So
You can't what?
we can't open our business because they blocked us. Without notice, they put the fence up. Okay, and they've totally violated the development order. That's why they got a code complaint right away. That's why from not just me, someone else. And so even without notice, I couldn't get my dumpster out of there. And so, they've got a problem because they tore up the parking lot. They put a big fence up there that's illegal, by the way. It's 8 feet tall, not 6 feet. It's set in concrete posts. You have to have a permit to have a fence in concrete. It's a permanent structure. So they didn't go through the process. Nobody checked it out. The fire department had to come in late after the fact and do some kind of compromise. Well, if they're going to give up 2 parking spaces, they've already lost 7. They're going to give up 2 more. So you have a building that has 6 residential condos and 2 commercial businesses that are very busy. They do not have enough parking for what they have left. And they're still draining their water into my drainage basin. So there's a big mess here. I think that if we want to worry about public safety and worry about the parking code and worry about respecting the process, I'm the only person in that whole area that respects the process. I've gone through it for 4 years to get my building built. And right before I get ready to open, they put a fence up there because they don't respect the process. They just want to block me from opening. Okay, so this stuff that Mr. Pleat's saying, he's only telling you a very small amount of what's really happening there. And I would trust the county attorney and the code enforcement folks before somebody who just put up a fence without a permit and without going through the right process.
So in your view, it's not really about parking spaces or the number of parking spaces, it's just about keeping you out of business?
In my opinion, they're trying to stop me from opening. Why, I'm not sure, but if they were worried about parking, why would they block 7 of their own spaces, then give up 2 more for the fire department? Doesn't make sense, does it?
Now, do you have any plans to put your own driveway in?
Well, I'm going to have to, apparently. But the plans that Mr. Pleat was referring to, when I went through the process, it's ironic, Fish House complained that we didn't have enough parking per the original development order. Why did we not have enough parking? Because of the driveway. The driveway took up 3 parking spaces, which I thought was really ironic to say that I don't have enough parking because of the driveway that really benefits them. So rather than work with me on parking, I thought, if you're not going to work with me on parking, then I'll add parking behind my building. And the process of doing that was going to take too long, so I agreed with the county, I'll just make my building smaller so that I could make up for the parking spaces that were missing due to the Fish House's driveway. That driveway really didn't benefit me because I couldn't park back there. Why would I want a driveway that takes up parking for the entire development? So, that's why that was closed off, and it's actually been quite nice without that driveway because Fish House customers have to go back and park by the Fish House. So that's why the driveway was a problem for me, and that's why I sued to have it closed.
Okay, any other questions for Mr. O'Brien? Yes, sir.
If you permit, I'd like to ask some questions of the witness.
Okay.
Thank you. Mr. Leary, good evening. You filed, when you bought this property, were you aware there was a mutual access easement agreement that touched the 3 parcels?
I was aware of the existence of something in the title record.
And you filed a lawsuit whereby the 2 defendants were the Eastern Lake Village Condo Association and Coastal Innovations, which owns Old Florida Fish House, correct?
No, I did not. I filed a lawsuit against Old Florida Fish House, and the condos, actually, Mr. Pleat made a motion to bring the condos into the lawsuit.
And both were defendants at that point, correct?
Because you brought them in.
I understand, but both were defendants, correct?
Correct.
And it's a lawsuit that you brought against Coastal initially, and Eastern Lake was brought into the case, correct?
The condos either had to be a plaintiff or they had to be a defendant. I didn't want them in it because it was just about my little piece of the land there. But Mr. Pleat got them into the lawsuit.
Try to listen to the question if you would. The question was, you sued Coastal, the owner of Old Florida Fish House, correct?
Right.
And later, as we've noted, Eastern Lake Village was brought in through a motion. They were also a defendant in the case, correct?
A motion by you, yes.
Yeah, understood. Has Eastern Lake Village Association ever filed a lawsuit against you or your company?
Not that I'm aware of.
Has Coastal Innovations, the owner of Old Florida Fish House, ever filed a lawsuit against you?
No.
You are currently suing Eastern Lake Village Condominium Association in federal court, correct?
Correct.
And you're seeking damages for loss of business revenue, to take down the fence, for Americans with disability arguments as well. So it's your second lawsuit involving my client, and also the first was against Coastal. But you're suing them for money damages relating
Mr.
to...
Chairman, I'm going to object. This is not relevant to our proceedings.
I would accept that objection.
So it's your belief that there's a need for a modification to the development order in order for the fence to be erected? Is that correct?
Correct.
You have a fence on the north part of your parcel, correct?
But that doesn't affect.
I asked a question. Do you have a fence on the north part of your parcel?
Yes.
And does it run from the Dune Lake, approximately the Dune Lake, all the way to Heron Watch Way?
No.
Does it run along the majority?
Wait. Is this a?
Yes, it is, and if I could explain.
In what way? Okay. In what way is it pertinent?
The county is claiming, and this witness is claiming, that the fence requires an amended development order to erect a fence. Yet this witness has just testified that Cotamolo, has its own fence.
Well, you could bring an action, you can go to the code enforcement and
I'm just
object to
simply
that
trying to-
fence, but at this point,
I'm just
it's
trying to
really
make-
not pertinent to this matter.
I would like to say.
Well, wait, one at a time, again.
I just want for the record to reflect whether or not he applied for a development order modification for before putting his fence up.
I don't see that he needs to answer that question.
But I would like to, it illuminates what I was saying. The fence I put up does not affect the infrastructure.
Talk right into that mic.
Sorry, the fence that I put up does not affect the infrastructure of the development. In other words, it doesn't bisect the parking lot.
Again, look, this fence is not part of the issue here tonight, so let's
Right.
just leave
I'm
that
just
part
saying
of the
it's
fence
totally
out of
different.
it.
It's apples and
It's
oranges.
confusing enough with the one fence. Let's
Thank
not do two, okay?
No further questions.
Okay.
Was there a permit, could I ask,
Yes.
was there a permit for the fence that's there, that they're building or whatever? Was there ever a permit, or did it ever go through the process of?
For my fence or
any
their
of-
fence?
the
My
one-
fence
the
is
one
only
that's
a
in
snow.
question?
No, the
No.
one that's in question.
No, there's
Their
not.
fence.
No, I
their
do not believe
fence.
there was no permit. Is 8 feet tall, in concrete post without notice, without anything.
No
Just-
building permit, no development order.
No.
That's what this whole
That's-
hearing's about.
That's right.
Exactly.
Okay. Sydney, you wanted to say something? Yeah.
Yes, sir, just
Thank
briefly.
you.
We need you at the microphone.
Okay, yes, sir. I think so. What am I, Dana? I'm gonna try to be brief, but I just wanted to go over a few things that Mr. Fleet addressed. Hannah's gonna help me here real quick. I'm gonna try. Actually, we can do it without that. We can go ahead and start. Well, there we go. So this is the layout of the three properties. It's now three properties. I thought that I would bring this up. Oops, sorry, Anna, put up the aerial image. There we go. So Mr. Fleet, and let me get back to the microphone now. I believe I got that pulled up. So Mr. Fleet made quite a bit of the 2002 access easement between Three Amigos and Eastern Lake, I think it was Eastern Lake Developments. And it's in your packet of information that Mr. Fleet gave you. Can you tell me the page?
Sure.
There, I had it.
Page 86.
Thanks.
Is that red, the big box,
Yes, sir.
is that two parcels or one parcel?
So you can see, Mr. Wilson, that the outline, I guess the outer rectangle, that's the parcel that we've cited for the violation. That's owned by the Eastern Lake Village Condominium Owners Association Incorporated.
That's
And then
one
within,
lot.
I'm sorry.
That's one lot.
Yes, sir. And then within the middle of that are the individual condominium units that are part of Eastern Lake Village Condominium Owners Association.
And the fence is the far left red line going north-south.
Yes, sir,
Okay.
on the west
Well,
property boundary.
what's the inverted T then? What does that signify, the smaller area inside?
That's the
building,
building.
Yeah. So
Oh,
Mr.
that's the
Sanders-
actual building footprint?
Yes.
Okay.
Well, no, I think that's just the way the property appraiser depicts the upper level condominiums.
What are who owns the two squares on either side of the
Okay, so
top,
if
the
you,
bottom of the T, which
if
is
you
the top?
look to the property to the west is owned by Cotamolo. And then the property to the north is where Old Florida Fish House is located.
Right.
outside of the red triangle.
And Buddy's Seafood is where?
Is within the condominium for Eastern Lake Village Condominium Owners Association.
Within
Oh,
the
okay.
T.
Okay, gotcha.
So, sorry.
Time
But-
out.
Yeah, there you go.
Oh, well, we lost it. But what I wanted to point out as far as the 2002 access easement, just really briefly, because Mr. Pleat did make quite a lot of it, and that was a lot of his discussion. That was an easement between Three Amigos, which was the successor to the Old Florida Fish House. So that's the property to the north. So it was between Three Amigos and Eastern Lake Village LTD, which owned what's now Cotamolo's property and Eastern Lake Village Condominium Owners Association property. That easement was executed in 2002. That was 2 years prior to the development order for this project. So, Mr. Pleat made a lot of this mutual access easement agreement and that it had to do with parking for the property. Well, it could not have had anything to do with parking for the property because there was no parking there. It was 2 years prior to the development order. And I think it was Mr. O'Leary who got up and spoke. He's the owner of Cotamolo. And he said it pretty succinctly, so I'm not going to really repeat it too quickly. This doesn't really have anything to do with access easements at all. It has to do with the development order and whether or not that fence was placed there without the proper approvals.
That's what I think, yeah.
That's really all this case is about. That fence, Mr. Carpenter testified, is not contemplated in any way under the 2004 or 2016 development order approvals for these properties. There's no fence depicted. In order to construct a fence, they would need to obtain a development order, and they did not do that before they constructed the fence.
That's right.
It's that simple. That's what they've been cited for, and that's the violation. Mr. Pleat said that we're trying to argue that they are violating some mutual parking or shared parking. That's not the violation. If you look at Anna's notice of violation, which was introduced into the record, it's a violation of Chapter 11, constructing without a development order. Period, end of story. That's the complaint, that's the violation. So I just wanted to make those points very clear. Thank you.
Okay, thank you. Are we done hearing from the county? And Mr. Pleat, are you done?
Yes, subject to closing argument.
That was my closing argument.
Okay, well, I wish you'd make that closing argument, and then we will consider that. The gentleman with his hand up, who are you?
Mr. Oaks, I'm the president of the HOA.
Have you been sworn in?
No, sir.
Would you please step to the microphone and be sworn in?
Please state your name.
Jason Oaks.
Do you swear to tell the truth, the whole truth, and nothing but the truth during your testimony before this board?
Yes, ma'am. Thank you, gentlemen, ladies. We are in a point where we've tried to be good neighbors. I'm in the real estate business. This is one of the worst things I'd like to see. I like people to be able to use their property. The Buddy Seafood guy, he's a businessman, and we do not like where this has come to. We did not want to put the fence up, but we had no choice in our opinion because of the fact that Mr. O'Leary continued to invade our property rights, basically demanding that we give him parking when we had no parking to give him. He's the one that bought the parcel. We didn't. He knew that when he bought the parcel that there was limited parking. He was issued the development order. Whether it was right or wrong, that's not for me to determine. We'd love to see not only this fence, the one that's in question, but also the fences that he erected and destroyed all of our property and our sprinkler systems. We'd like to see all of them taken down so we can all access the property and make it look a lot better and be part of and make it look like it used to look. It looks terrible now. It took a lot for us to do this because it's hurt our business, especially Buddy Seafood. So this is not a win-win deal here for us. We were forced to take on a big burden financially when we did that, not only from the point of losing business, but Mr. O'Leary forced us to move our fire suppression system that was 4 or 5 feet on his property, cost us $33,000. He took away the pool, he took away access to the lake. Again, that's his property. We never sued him for that. We understood that. We understood that's what happened when the lot split
I'm
happened.
gonna object to this.
Yeah.
I
It's not
understand.
relevant.
Please.
It's not pertinent to the,
But it is pertinent from the standpoint that we do not want the fence. We never wanted the fence. We
yeah,
don't want.
but you erected the fence.
We
Okay, I
had to.
understand
We
your-
had to protect our property rights,
I
sir.
understand your reluctance, but you
That
did.
is- and that's all.
Here,
Sir, we have a court reporter, okay? Got one at a time for her. Thank you.
Okay. I understand your reluctance to have built the fence, but that really isn't pertinent. The fence exists, and that's what we have to consider.
Okay, thank you, Mr. Stein.
Thank you.
And there's no permit, that's the main thing. I mean, you didn't go through the orders, the process to get the fence, and evidently he didn't either for his, I don't know.
He did, and we asked him when the trash can was there. We told him to go ahead and move his stuff, and he didn't. And in fact, he's piled it up there.
Okay. Mr. Pleat, you're going to make a closing argument.
Yes, and I will do my best not to be redundant. I do want to point out, though, within the testimony.
Would you step up to the microphone so we could hear you better?
Yes. In the testimony of the county through Ms. Reichert, she was very clear that the fence is disrupting the shared parking rights of the complainant, that there's a shared parking violation here that's associated with the action of the county. The fence happens to be the mechanism that's blocking that shared parking. So I think the testimony and the record in this case reflects that the county's motivation is parking, that the fence disrupts their belief that the parking should be accessible to the complaining Cotomolo parcel. And I just reiterate that there was access, that it was voided legally, and for the board to find that there's a disruption of shared parking, you must first determine there is a right to shared parking. And that requires the board to determine what's the legal basis that provides a fee simple owning property owner to have to permit another property owner to park in their parking that they don't own if there's no easement.
Okay, thank you. All right, any further word from the public? If not, we're going to close the public part of the hearing.
Tom, I have a couple of questions for Mac, if I may.
Okay.
Yes, sir.
Mac, what should have happened here to resolve this issue in terms of the property to the west? And what could have happened in terms of the parking and the stormwater to have taken care of this entire situation to eliminate this problem?
Well, first of all, the 2004 development order, because of the way it was structured, means that these two parcels are going to be together until they amend the development order and separate themselves. They have not done that. We treated the Cotomolo parcel as an amendment to the original development order. There was, I think, some parking that was not installed. We went back and recalculated the parking. There are 10 spaces on the Cotomolo side of the fence. That's adequate. That's actually more than adequate to serve their particular need. The problem is not the shared parking. The problem is how you get into the parking lot through the drive aisle. We now have a fence in the middle of the drive aisle preventing you from driving into that entrance off of 30A and accessing the parking to Cotomolo's side and their dumpster and accessing the parking right in front of Buddy's Seafood.
Mac, would you consider this fence a wall?
It could be considered a wall. I mean, it's a wooden fence, but it's placed in the middle of a drive aisle.
Thank you.
I have one quick question for Ms. Reichert.
Yep.
As of the last time you were out there, was there any provision any provision at all been made for emergency vehicles?
Not that
Oh.
I could tell.
Okay.
And I don't work for emergency, so I don't know what they would be looking for. So,
Any changes, pertinent changes at all?
no, sir.
Okay, I'm going to close the public part of the hearing, and now we're going to discuss this amongst ourselves. What is
I think
this?
this was pointed out, that this is an unpermitted fence
Yeah.
that has been installed,
Yeah,
and the shared parking I don't think it's even relevant.
I don't either.
Right.
To determine, it's.
The
whether fence should be there or
violation,
not.
the alleged violation is a violation of the development order. They didn't get a permit to build the fence.
Right.
And they were notified on several occasions and didn't respond, did they?
Right, and then they felt justified in building the fence and keeping it up, so it's there. But we, as the legal arm of the county, have to agree that, hey, they didn't have a development order, they didn't have a development order.
In addition to that, I'd say that the fence is a public nuisance.
Well,
The parking
whether
lot
it is or
made
it
for
isn't.
public To get there, one way or the other,
We
and
need to
garbage
include all that.
service.
I mean, you just, show me your
You
development
know,
order. You
we were
don't
looking
have
for
one,
motivations,
take that
talking about the parking, and the motivations are irrelevant.
Yeah, exactly. The motivation's irrelevant. The fence exists.
It's
Okay.
nice to know.
I move that we give, can I make a motion? Yeah, please.
I move that we give them 30 days to begin the process of development order. At the end of 30 days, if we don't have that process in being, we start the fine of $250 a day until they do it.
Wait a minute, you want them to get a development order to build the fence?
It's a permit. Start the permitting process for the fence.
What about the fence?
Well, the
Yeah.
permitting
Fence is the
process could go on forever.
All right, well then.
They've already violated.
You wanna make them tear down the fence?
Yes.
Yeah.
Yes.
I mean, it's
I'll
black and white.
I'll withdraw my motion.
It's black and white. It says they built a fence without a development order. Did they build a fence? They feel justified. Everybody feels justified in their position, but the fact is, there's a fence up there that was never permitted.
Anna, would you,
No, it's over. You can't, we
what
close
was her recommendation? 1, 2, 3, 4, 5.
$250 a day until they come into compliance. They
Give
had
them
until
3
8/20 to come into compliance.
Till August 20th,
Yeah.
to remove the fence.
Right.
And then it starts, well, what I wrote in my notes, 3 days, or August 20th,
Right.
to remove the fence, and then it starts $250 a day.
Right. And then they can start the development process or not, whatever they want. That's their business. What Max seemed to say at the end there was, that's really what needs to happen. Because everybody needs to get their own development order and deal with their own parcel.
3 days to pull the fence down.
Yeah, well, all you gotta do is go out there with a chainsaw.
It shouldn't take long to take the fence down.
And they could reuse it.
I suggest we give them more time than that to get it down, but it is a hazard for, as far as safety.
Well, and it
Public
blocks that
safety.
guy from his property.
And having the fence removed doesn't grant anybody any other rights. I mean, like we were talking about, it's only the fence removal. We're not granting
Right.
anybody rights on anybody else's property.
Right. We're not getting into that issue at all.
That's not our prerogative.
All right.
Could we see the
So-
recommendation that the officer made before us?
That's what it was, 3 days.
That's what it is. It's,
3
she's got
days.
till,
We got
no,
it- we
no,
got it in
look.
writing right
No, we're not gonna do it. We closed the public part of the hearing. She said 8/20, she needs to come in compliance or $250 a day. You can believe me, I wrote it down.
It's not, you can read it.
And did that have to, did she say tear down the fence?
Remove the fence.
Remove the fence, yes.
Okay. I'm with you now.
Tear down the fence
Yeah,
and clean up the trash.
sounds like Ronald Reagan.
Okay.
Okay.
Mr. Gorbachev?
So the motion should be that we concur with the recommendations of the code enforcement officer, and all those in favor?
No, we need a second to that motion.
I second.
Yeah.
All right, does everybody understand the motion? Then it's simply, the fence needs to be removed by 8/20 or a fine of $250 a day. All those in favor? Aye. All those opposed? The motion carries unanimously. All right, we got one more case, and we're gonna go to it right away. And it's case number 3, 18-1601. And who's gonna talk to us about this one?
That would be me, Mr. Chairman. Just a second.
Yes, sir.
Good
Introduce
evening,
yourself,
Board.
please. Yes.
I'm Code Enforcement Officer Michael Lynch. For the record, I'm submitting my final report and presentation. This is case 18-001601, Parcel number 24 to south, 21-42311-0000110. The case before you is the property of Alma H. Lowry, residing at 35 Cobia Court in Santa Rosa Beach, which is an unincorporated area of Walton County. The land use is residential preservation. The LDC violations that I'm citing tonight is 2.01.03J, 2EI, which is general regulations and requirements applying to all 5 types of development projects within an MPA, which is a neighborhood plan. Also 2.01.03J, 3A, III, which is density mix and standards for each specific type of development project allowed within an MPA, specifically residential preservation areas. 6.02.02, home occupations. 5.07.08B, duty of maintenance of private property. And 5.07.08C, exterior storage of non-operating vehicles, junk, or debris. Sounds like a lot, and I know you've been through a lot this evening. I'm going to try to keep it simple. This is the parcel in question. The red shaded area is the Lowry project parcel. To the right of this parcel, and I'm going to tie this in, this is a parcel owned by a young lady named Amber Borg Grinnell. And there's some pertinent things going on with this property as well with Miss Lowry. And I'm sorry, this thing is okay. Specifically, the code violations that I had referenced, the specifics are in yellow. Basically, no new commercial or workplace use shall be established within a 250-foot buffer around areas which meet the definition of residential preservation. Also, non-residential uses are not allowed in this district unless part of a previously approved plat or development order. There shall be no, under home occupations, there shall be no change in the outside appearance of the building or premises or other visible evidence of the conduct of such home occupation. I'm going to stop right here for a second. The reason that I'm citing these is that on this parcel there is a limousine service being operated. Okay, several vehicles parked going in and out of this property a day. Large vehicles, takes up a lot of space. And under a residential preservation area, you can't operate a business like that. And so each of these separate citations are referencing this business. You can't have any outward appearance, and it can't impact. It's not supposed to be within 250 feet of a residential area, so that's why I cited these. Under duty of maintenance, no owner of any premise shall maintain or keep or allow any tenant, lessee, occupant, or other person to maintain or keep any nuisance thereon. Part of the complaint in this case was a large boat that is in disrepair, that the complainant was able to see over a privacy fence that abutted on the far side. Under the nuisance, this boat would clearly qualify. It's in disrepair. I'm going to show you aerial photos from the property appraiser's website. Since 2008, the boat hasn't moved. It looks like Gilligan's Island. It's really in bad shape. Also, exterior storage of non-operating vehicles, junk, or debris. No owner of a premise shall allow partially dismantled, wrecked, junked, discarded, or otherwise non-operating or non-registered or unlicensed motor vehicles or junk to remain on such property longer than 30 days. There are a minimum of 4 junk vehicles, a couple of which I believe are extending from the subject property onto Miss Grinnell's property. And that's why I'm saying that it's irrelevant.
Hold on.
Oh, sorry. The chronology of this case, and I'll try to be brief. I don't believe Mr. Lowry or his mother are here to speak. But on April 18th, I received a complaint of junk debris and an old boat. I went and I observed the property. You're going to see photos here in just a minute of inoperable vehicles and old boats. I did speak to the property owner, Miss Alma Lowry, and her son Sheridan Lowry. Mr. Lowry promised me that he would take care of these matters in 30 days. There's an old tractor trailer storage trailer that looks like it's partly across 3 lots. It looked like it was his lot, Miss Grinnell's lot, and then a lot to the north. It's his. He said, you know, that's mine. I use it to store things. And he said that he would move it behind his mother's house onto their parcel. He said that he would do that within 30 days, and I gave him the 30 days. But I also told him, I said, you cannot operate this limo service from this property. It's a violation of the land use. He had a disagreement with that, and I said, well, we'll have to address that then, because it is. I came back a month later on May 18th, re-inspected the property. I found no change at all. I attempted to contact Mr. Lowry by phone, ended up having to leave a voicemail. I also sent on this date a notice of violation to the property owner via certified mail. On May 25th, I re-inspected, hoping to find some change. There was no change at all. As well, on May 31st, I again attempted to contact Mr. Lowry and again left a voicemail. On June 14th, I attempted to contact Mr. Lowry, again leaving a voicemail. On the 15th, I re-inspected, found no change at all. I did make contact with Mrs. Lowry and discuss the violations. Her attitude was, the county doesn't have the right to tell me what to do on my property. And I said, well, you purchased your property after the implementation of the LDC. Okay, that makes your property subject, to the county land development code. Mr. Lowry then arrived. Again, I discussed the violations. I told him, I said, man to man, you promised me within 30 days that you would have these things corrected, and you've done nothing. He became rather obstinate, and again, he said, well, I'm a realtor, I know the law. And I said, well, then you should know that you cannot operate a business from this property. After a heated exchange on the front porch, he did agree that if I gave him another 30 days, that he would comply. Come on. There we go. So, to back this up and just to check, I conferred with Vivian Schammel and Director Carpenter regarding a limo service, and both indicated in residential preservation this would not be allowed. On June 26th, I received the return NOV as undeliverable. I sent it to their home. There's no other place to send it. They just didn't want to sign for it. On July 17th, giving them a full 30 days, I re-inspected the property and again found no change whatsoever. On the 26th, I contacted the adjacent property owner, Miss Amber Grinnell, by phone, asking her permission to enter onto her property to photograph the conditions of her property and that of the Lowry property. Miss Grinnell gave me her permission and asked that I share the photos with her that show the condition of her property. Now, at this same time, I attempted to hand deliver a notice of hearing. I figured if they didn't sign for the notice of violation, they sure weren't going to sign for the notice of hearing. So I had the notice of hearing and the notice of violation. I was going to hand deliver. I rang the doorbell. I knocked. I know that there was somebody inside because as I was taking pictures, there was a lady, not Miss Lowry, but there was a lady in the back of the house looking out the window. I waved at her. She waved at me. I know somebody was in that house, but yet they would not come to the front door. On the 27th,
Did
the
you
next
leave-
day.
Did you leave the notice of hearing on the door, or?
Not at that time, sir. I preferred to give hand delivery, so I was going to give it one more shot. So the very next day, I attempted hand delivery again. Sorry. There's my wife. Okay. I think you've seen her before. On the very next day, I tried again to hand deliver the notice of hearing and notice of violation. I rang the doorbell, knocked on the door, and I know somebody was inside this time because after I knocked on the door, I heard what sounded like little feet running across the floor. I mean, I actually physically heard somebody inside the house. So again, I know somebody was there. I ended up posting the notice of hearing and notice of violation on the front door of the residence at 12:18 p.m. I had another property at the end of Shelter Cove to check on, and by the time I came back approximately 20 minutes later, as I drove by Cobia Court, I looked over at the front door, and the notices were already off the door. So I know somebody was inside. I know they've received it.
Is this in the Blue Mountain Beach area?
No, sir. The easiest way to describe it is if you go up Goldsby over by Walmart or the Small Mart, go due north, go through two stop signs. It's at the very top. Shelter Cove then takes off to the west, and then Cobia Court is immediately off of that. So after that, I then came back to the office and I posted outside our door here in the front the notice of hearing for the Lowrys, satisfying the requirement for posting. I posted it on their residence and here at the courthouse. Apologize for getting out of breath. I know it's been a long day. I'm trying to go as fast as I can. On the day of the complaint, these were the conditions. The white limo that you see here, I believe, is Miss Lowry's personal vehicle. She's got handicap plates, and it's hard to tell. There are two Mercedes side by side, one on the parking pad, one on the grass. I believe, and I haven't had the property surveyed, but I believe that vehicle to be either wholly or partially into Miss Grinnell's property. Directly behind those two vehicles is a pickup truck with a camper shell, and I've got better pictures of that. On the other side of that pickup truck, there's a black Acura, also inoperable, flat tires and in disrepair. Come on.
Is that picture taken from a public
Yes.
road?
Yes, Cobia Court is not a county-maintained road, but it is a public access road. So I was legally able to be there. Oops. This is towards the front of the house and towards the end of the little cul-de-sac. This was the boat that was part of the original complaint. On the back side of that, there's another development, and I apologize, I don't know the name of the development, but there's a privacy fence, a 6-foot-high privacy fence. And as you can see, that large boat is going to be very visible from the other side of that fence. The other property owners have no choice. They have to look at this. It's parked right up against the privacy fence. There's also a smaller boat in disrepair as well. And in this picture, you can see two of the limos that are being operated out of this property. Here's a picture that I took when Miss Grinnell gave me access to her property, showing the two Mercedes that are in disrepair. The pickup truck that you see there is actually up on jacks. It looked like the transmission and part of the engine was being worked on. This is the black Acura that was behind the pickup truck that I was I'm sorry. And of course, throughout their property, there's junk and debris as well. This is a copy of the notice of violation that I originally sent. Here is the returned certified mail as undeliverable. They circled 5. I don't know if that was 5 attempts to deliver, but it came back as undeliverable. On the date that I posted on July 27th, on the left you see the notice of hearing, and on the right is the notice of violation that they were posted at 12:18. This is the posting of the notice of hearing out here in front. It should still be in the box here at the courthouse. And this is the affidavit of service that I signed and had notarized by our administrative assistant, showing that I had posted the property. Now, this view is taken, this view is taken from Cobia Court and looking across Miss Grinnell's property onto the Lowry property. And initially, I thought it was all one parcel because Mr. Lowry said, identified this as my stuff. He said that the property owner had given him use of the land that he could store things years ago. And I said, well, that may have been his agreement. Unfortunately, in this land use, he can't let you store things like this. And in the back, you can see that large orange trailer. To the left of that, there's like 2 flatbed trailers stacked. And then further to the left, you're going to see in a moment, is a broken down pickup truck. But there's a trash can with his number, 35, on Miss Grinnell's property. At the base of that tree to the right, there's a large pile of shucked oyster shells. And all I was asking the guy to do is clean it up. I mean, I could have done this in a matter of hours, but it took him 30 days, and he still didn't do anything. This is a closer photo. You've got a camper shell back there. You've got what looks like a paddle board, another old boat, different car parts. You can see the 2 flatbed trailers. Here is the broken down truck. There's some car seats and part of a car door, and I don't know what type of molding. It looks like it was maybe the dash of a vehicle. And again, all this is on Miss Grinnell's property. Here's the shells. The 35 is his garbage can on her property. There we go. And another overhead photo, and the reason I picked this one is you can see the tire marks going across Miss Grinnell's property into the back of the Lowry property. On one occasion, on one of my visits there, I witnessed one of his limo drivers driving his personal vehicle in, getting a limo, and then driving out. They use Miss Grinnell's property as their own. I've also observed Mrs. Lowry's Lincoln Town car parked in the middle of her property, of the Grinnell.
Where is Mrs. Grinnell? Is her property developed at all?
No. No, sir. Now, Miss Grinnell lives in Crestview, and she wasn't sure if she would be able to be here. I invited her to speak. She wanted it to be very clear to Mr. Lowry that she did not allow anybody to store anything on her property. She sent him a certified letter, which she has forwarded to me, showing her intent. She does not want anybody using her property. And what I'm going to ask the board is to consider the impact that these people are having on their neighbors. The people that have to look at the boat, the people that are having their property violated. Now, this morning, first thing, I went out to show you the conditions. This is actually from Shelter Cove, and I know it's a long-distance shot, but even here, you can see the limos lined up at the very center, and that big boat and the small boat. We actually had more vehicles. We had the 2 Mercedes, the pickup truck, and the Acura, and then there was a pickup truck with a rack on the top. This is from the front again this morning, showing the limos lined up out front. He has a 4th, it looks like a Hummer, and I don't know whether it was out on a job, but it's even a larger vehicle than the one that you see here. And this is the front of the property. And then this is just showing the overall proximity. Again, he hasn't moved the trailer. He hasn't cleaned up anything on Miss Grinnell's property. He hasn't taken care of anything on his mother's property. And I'm willing to work with anybody. To date, I've opened 472 cases in the county. And this is my 3rd case before you. Most of the people are compliant. I'm willing to work with anybody. But in this case, when Miss Lowry said that she didn't believe that the county had the authority and the place to tell her how to run her property, I had no other recourse. So what I would ask the board is that you find that the address of 35 Cobia Court is located within the unincorporated area of Walton County and is subject to Chapter 12 of the Walton County Land Development Code, that you find that a violation of the Walton County Land Development Code sections 2.01.03J, and there were 2 citations under J, also 6.02.02, that was the home occupation, and 5.07.08B and C do exist on the property, that the property notice, the proper notice of the hearing was given to the respondent, that the respondent is to correct the violation within 30 days of the date of this order, and that the respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify compliance with this order. That if the respondent fails to comply with this above action or fails to bring the property into compliance with the applicable code, ordinances, and regulations according to this order, the board assesses a fine of $250 a day until the property is brought into compliance. I'm not addressing and I'm not asking the board to make Mr. Lowry clean up Miss Grinnell's property. I'm just asking that he be made to clean up his and his mother's property. Miss Grinnell has given him her own timeline in which to clean up her property. Otherwise, she's going to seek civil remedies for that. I did not want to bring her before the code board, even though her property could be viewed as in violation, because I intend on holding the party responsible for that.
I have a question. He has an exhibit from the neighbor in this thing. Can we accept that?
There's no one to object to it, so it's up to the chairs to whether or not he accepts that.
I mean, it's a third party letter that's in there that's not verified, so I didn't know if that was hearsay or not.
It's no one has objected to it, so the chair can find it to be so, but.
Yeah, I'll accept it.
What's the land use classification for the property?
Preservation.
Land use, it is residential preservation.
For
Which,
all of this property that we're...
Yes. And looking at the surrounding properties, it's a nice area. The only eyesore is this one. And that's why we're, trying to, bring this property into compliance.
And there's really not a remedy to put a business that doesn't fit in with home businesses in a residential area like this.
Well, under residential preservation, I'll give you an example. My wife works for Cigna. She's a case manager, a nurse, and she handles people's files. There's no signage in front of her house. There's no traffic. We have no patients coming or going. But her company has set her up with a home business, computer, phones, this, that, and the other. So there's no outward appearance. It doesn't have any impact on the neighborhood. But we're not in a residential preservation. But even if we were, that type of business would be permitted because it doesn't violate any of the provisions of those codes that I cited.
The only indication you have that he's running a business there is all these limousines, is that right?
That and the SunBiz.
The what?
The SunBiz registration, they are listed for their limo service.
Their Florida licenses?
Yes, sir. It's 35 Cobia Court.
Okay, so it's the address of the business.
Yes, sir.
Who brought the complaint?
I'd have to go back and look in the file.
Oh, it's Mrs. Grinnell.
Yeah, I sure would.
Well, that would make it simple. I know it's not Miss Grinnell.
Yeah, that messed up her civil case.
You want to close it, Tom?
Yeah.
Let's talk about this, let's shut it down.
It was a neighbor on the other side of the fence.
Oh, the guy who had to look at the boat?
Yes.
Okay, we'll close this part. You're done?
Yes, sir.
Okay.
Oh, wait, I'm sorry,
Whoops.
Mr. Stein, would you accept his presentation into the record?
I certainly would.
Yes, thank you.
Okay.
I'm sitting here listening to this, this is another Patterson case. We're gonna find this guy $100 a day or $150 a day for the next 22 years. He's gonna walk in here, and it's $246,000, he'll say, I have no money, and we're gonna let him out the door for $15. I mean, we have approached this differently.
Well, for one, I won't be here in 20 years.
What? But the point is, if this guy's trespassing on other people's property, let's turn it over to the people who handle trespassing cases. We're not gonna solve this.
I'm ready to make a motion, Tom.
Go ahead.
We accept the officer's recommendation.
$250 a day. Well, what else can we do?
That's all you
Oh,
can.
will somebody second it?
Make it.
Somebody second it.
I'll second.
Okay. Well, Gordon, we'll give Gordon credit.
Yeah.
Okay.
Let's discuss a little bit.
Well, I mean,
I have
Just, I just say that it might not need to be $250, just to avoid this $250,000 business. Maybe with a business like this, I can't imagine if you say 250, that's just total out of the ballpark. If we get it in the ballpark and something that is perceivable.
that's an interesting argument, but I can't go
That, where we could come back and say it's $50,000 after 20 years.
All he's got to do is move his limos out of sight. That's all he's got to do, and clean up the property.
Yeah.
He could dispatch him from there, but he's gotta get him off the property.
Correct.
Well, he don't want to rent another place.
Well,
That's all he's got to
it's
do.
his
It's not,
business.
it's a pretty simple thing. I mean, it really is.
Well, but these are privately owned automobiles.
Yeah, the business has got to go. I mean, I'm all for that, but I'm just saying this fine business ought to be something that he.
But I don't even understand why he can't park his own cars in front of his own house.
It's a commercial
It's-
entity.
Commercial vehicles.
It's a commercial entity.
Yeah, okay.
Now, if it was, like you said, if he had the vehicles off premises, he could run the business out of his house.
You have park.
He could dispatch them,
Do you know
but
who
you
drives
can't
these-
have all those things sitting there.
Who drives these vehicles, do you know that?
I don't know their names. I only saw one individual. But you're right. I mean, they could be dispatched as long as as long as there's no outward appearance to the neighborhood that a business is being operated, it would be well within, the code.
He could probably store, if he had a big barn, he could probably put them in and hide them. But
This has been going
I
on
can
for
understand.
Well, look, we
years and
Let's
years.
call the question.
It's been going on.
Again, look, we're here to decide whether or not the violations that he's been cited for, he's in violation of those, and
the amount of the fine.
the amount of the fine. Okay, it was pretty clear, he's in violation. We don't need to give him a business plan. We don't need to
Exactly.
earn the guy a living, all right? If he was stupid enough to try to run a business in a place where it's illegal, hey, buddy.
Yeah,
I'm
we've
trying to
had this
reach the
before.
most
Let's
effective fine.
Go ahead.
call the question,
So-
let's get it, yeah.
Anybody, if I, yeah, call the question, all right, all those in favor? Any opposed? So it carries, $250 a day
No,
after
he-
30
We had
days.
one opposed.
Oh, I'm sorry, you did vote against it.
I voted against calling the question.
Oh. Well, you got overruled.
That's a vote too.
Well, let's see, can you, really?
Yeah.
Is that true? Do I have to,
You call the
Vote
question,
on
you
question.
vote on whether the question's continued.
okay, well then let's go back, okay?
Yeah, sorry about
And
that.
now, we're gonna vote on calling the
I
question.
just want to add that a more effective fine would be something less than, more in the neighborhood of $100 a day in this case.
Well, I'm not gonna amend my motion, so.
We have multiple violations going on here. We have a business violation, then we got trash, junk all over his property.
Inoperative vehicles.
Yeah, so are
Yeah, I'm all for it, getting
are
rid
we
of it.
addressing everything here with this?
Yeah,
with this
yeah.
$100?
Every one of these violations.
All right, so we're putting them all together for $100 a day, or whatever.
250.
250 today.
Victor's motion is 250.
Accept an officer's
Okay, and
recommendation.
now we're gonna vote on calling the question.
Well, the
Okay.
question,
Okay,
that's
which
already
is,
been denied.
That,
look, this is just to be
No.
parliamentary correct, okay? So we'll vote on whether or not we're gonna vote, okay? So
We'll
all
vote on
those who
whether
wanna
we
vote, all those who wanna vote on Victor's motion, say aye. All those who don't, say aye or nay. That's you.
I don't know what I'm voting on anymore.
Okay, now we're gonna call the question one more time. We're gonna vote on Victor's motion, which is to find the guy guilty of all these violations and to assess a fine of $250 a day, beginning in 30 days. Yes, sir.
Non-compliance.
Okay, so let's ask that question again. All those in favor of the motion signify by saying aye.
Aye.
And all those opposed?
No.
Okay, that's two. I'm voting aye. So that's 1, 2, 3, 4, and 2. Okay, so the motion passes. And he's fined $250 a day if he doesn't come into compliance in 30 days.
Can we go?
Why aren't we
Okay,
charging
wait.
$250
I need
per
somebody to
violation?
make a motion to eliminate, or to adjourn this hearing.
Have we
I thought
bundled,
we could
have
do
we
that.
bundled all the violations into one
Yeah.
$250 a
Yeah.
day?
Yeah.
Well, why don't we charge him $253?
I don't think we can do it.
No, you can't. We tried that before. I recommend we adjourn.
And we are adjourned.